a special guest. Anybody who has been a student or studied the anthropology of the Muslim world probably came across the works of our guest, Professor John Bowen. I was fortunate enough to meet him a few months ago in New York, and I just would like to say that Professor Bowen works in a way that we consider to be pretty much in tune with the way this faculty was founded and the way our center works. He works in the Muslim world. He worked originally on Indonesia, and then he decided to move on to another realm, namely the Muslims of Europe, who are a very important part of the Muslim world nowadays, of course, but remain relatively understudied. Professor Bowen's approach is one that integrates not just fieldwork methods, but also an interest in the way Muslims engage with the textual heritage, whereby the diversity of the Muslim world, as I understand, comes to the way Muslims approach the tradition and how they're engaged with it all the time. So there's continuity and change, which is exactly the same way I've been thinking of the study of the Muslim world, but I have to say Professor Bowen, his works, puts it in much better terms than I ever could. He's a professor at the University of Washington, St. Louis. He occupies the position of Dunbar Van Cleve in Arts and Sciences. His many works, include particularly recent textbook on the anthropology of Islam, which has become a standard book for many of us to engage with. And I just mentioned his research works. I think his most recent fieldwork experience has been in France and England. So I'll leave the floor to Professor Bowen. He will talk to us for about 50 minutes, and then we move to questions. Please welcome our guest. Okay, thank you.
Right, how's that? Can you hear me all right?
Yeah.
Wonderful. Thank you very much. Thank you so much for inviting me here. It's a great honor and privilege to be here at this important center, at this important foundation in this country, which this is my first visit to. I'm enjoying it very much for the richness of the scholarship, of the people, the beauty of the country itself. So thank you once again very, very much. I'm going to be talking today about institutions that ground their legitimacy on very old texts and traditions, but have been set up in new countries. And my object is Sharia councils that have been set up starting in the early 1980s by Muslims living in Britain. Is there an annoying ring here, or is this about right? I think if it could be turned down slightly, I think there'll be a little less of a ring. Yeah, just turn the mics down slightly, please. Thank you very much. Now, so this analysis of a particular object, that's very good, thank you, points towards broader questions about religious change and continuity. So the broader question is when Muslims come from a number of distinct homelands to a number of distinct destinations in Europe and North America, for example, what gets transplanted, what gets left out, and what is altered? How much is path dependency, you keep doing the same things that you used to do, and how much is fitting in, adapting to new circumstances? Now, this is what I study, and I do so by working on two levels. One is I trace how Muslims have fashioned and are continuing to fashion new social and legal institutions in respect both to past experiences and new possibilities. That's the broad level of institutions. The more micro level involves focusing on moments when key actors in those institutions cite past practices, textual resources, or any one of a number of other justifications for what they do and ought to do. So I'm interested in broader institutional context, but also in these micro situations where various actors are trying to justify the moves they're making in Islamic terms, but in a new place. So I focus on a very narrow question: how does a woman get a divorce in Islam? I'll be saying a few things that you all know, excuse that, I just want to make sure that we all start from the same basic knowledge. That whereas a man can perform a divorce by himself in Islam, a woman usually needs either to persuade her husband to divorce her, often by giving him something, or to request a judge to dissolve her marriage, usually on specified grounds. And in most states with Islamic legal provisions, statutes or jurisprudence regulate divorce, and both men and women need to appeal to a judge. But what happens if Muslims wish to create institutions outside the state, without that state judicial backing? And what happens when they move to new countries where they can no longer rely on shared social expectations and the enforcement powers of the state? How do self-appointed authorities justify their power to divorce to the parties involved and to broader Muslim and non-Muslim publics? So these are the issues signaled in the title of my talk. What happens to a desire to follow the Sharia in a state without provisions or institutions of Islamic law? Hence the interest of the UK. There are many Muslims now living in the UK, many of them from South Asia. Here they find themselves praying in Russell Square Park, a very public place. And they're settled disproportionately in certain parts of the country, in the Greater London area, in the Midlands, and then further up in the north, in Yorkshire, Leeds, Bradford, places like this. So the area around Manchester and over to the right towards Leeds, the area around Birmingham, the Midlands, and the area around London have great concentrations of Muslims, which have allowed them to build up institutions that attract clientele from these rather dense Muslim publics. And as they've moved in great numbers, there has been some friction with the local people, different customs, different ways of dress. That's what's signaled here, different expectations. Now, among all the Western countries, it is in Britain that we find the furthest development of Sharia-based institutions on a broad range of scales, including halal food certification, Sharia-based financing, and the most controversial institution, Sharia councils. There are perhaps 10 to 12 such councils in Britain. They focus on requests by wives to dissolve their Islamic marriages, or the religious component of marriages conducted in Britain. These councils give advice on a wide range of issues. There are also very many other individuals in Britain, as elsewhere in Europe and North America, who might take it on themselves to declare that a marriage is over in its religious quality. But I'm really interested in these councils. Let me just mention 3 of them briefly, and then I'm going to focus on the third. I've been studying a number of these. First of all, Sufis make up the largest number of Muslims in Britain, and they tend to have the most visible mosques, such as this one, the Gamkul Sharif Mosque in Birmingham. There are many others. This is an outpost of the Sufi center of the same name in South Asia. One well-known mediation service, which also gives divorces to women, is located around the grave of the only Sufi to be buried in Western Europe. Right here, a man named Muhammad Abdul Wahab Siddiqui of the Naqshbandi order. On these grounds, the 84-acre community called Hijaz, located in the Midlands, the center draws its spiritual attractiveness from the shrine, right here, and the presence of the saint's son and successor, Faiz al-Aqtab Siddiqui. He's also a barrister as well as being acknowledged as a peer among the Sufi community. And he has sought to include the mediation activities of his Muslim Arbitration Tribunal within the community. Every year there's a blessed summit with performances of zikr and the arrival of many distinguished members of the community, and families come weekly to enjoy the meditating in the grounds. So that's one kind of a Sharia council, but it's a very specific kind of institution really focused on the spiritual attractiveness of the deceased saint and the continued presence of his son and successor. There's another example, number 2, located at the Birmingham Central Mosque. This is the largest mosque in Birmingham. It's a very open mosque, one of the few that doesn't cater to a particular kind of clientele, has people from all kinds of Islamic tendencies coming to it. And at this mosque, a Sharia council grew out of a women's crisis center, initially set up to help women who were having family problems. The head of the mosque, a man named Muhammad Nassim, said that they ought to add on a Sharia council as a kind of judicial component, as it were, to end the marriages of women who were having great deal of trouble with their marriages, perhaps even domestic violence at home. And what's interesting about this Sharia council is that there are a number of women who really take the lead. So this woman here on your left, R Bowen, one of the members of the council, really takes the lead in welcoming the women who come to request a divorce, in posing questions, This is the head of the mosque here, Mohammed Nassim, another scholar, and there's sometimes a fourth as well. Most of the day-to-day work is done by women, one of whom is a medical doctor, the ones who initially began this crisis center. So that's a second example of a Sharia council, but it's a very different kind of institution, given its history and its particular focus on resolving women's difficulties. Interestingly, the fact that women take a leading role in this council seems to have the full support of those who attend the Birmingham Central Mosque. Finally, I want to talk about the most prominent Sharia council in Britain. It's located in East London, in these premises in Leighton, East London. It's called the Islamic Sharia Council London. The rest of the talk is going to be about this particular example. It has existed since 1982. It has representatives in many large cities, and they form a kind of a network of correspondence. So women and men can visit these people in most of the large cities in Britain, pose their questions, propose a divorce if it's a woman seeking a divorce, and then the question and sometimes the proposition of the corresponding scholar will be sent down to London, and at monthly meetings the scholars will deliberate on these issues. Every day there are 3 or 4 leading scholars and other junior scholars resident in this Sharia Council in these offices. This is Suhaib Hassan, who's the leader, the founder and the leader of the group from Pakistan, who's meeting with 2 young women to talk about the divorce request of one of them. And at the monthly meetings, Suhaib with other scholars, it can be as many as 6, but it always has to be 3, deliberate on whether or not to grant the divorce request coming from a particular woman. Most of the scholars come from South Asia and were educated in Deobandi schools or in other schools following the Hanafi madhab. One scholar comes from Saudi Arabia, that's Haytham al-Haddad, right here, an unusual photo of him without a hat on. And a number of them have studied in Medina and in Riyadh, including Suhaib Hassan. So there's an interesting mix of scholars. They bring together Hanafi, Salafi, and other viewpoints, and they process hundreds of cases a year. Now, the British experience in colonial India provides the crucial backdrop to the council. British rulers decided to govern marriage affairs within each of the religious communities under their rule by the traditions and laws of those communities. As they extended legal recognition to more and more of those religiously defined communities, they created a set of regulations for each one that judges and administrators could apply. And then, indeed, this process in South Asia, in the colonies, resembled a process taking place at home at the same time, whereby Britain gradually extended recognition of marriage by communities of Jews, of Quakers, eventually Catholics, and other Protestant groups. So there was a parallel in Britain, in the metropole, and in the colonies. By the 1920s, Muslims in India, starting in the state of Bihar and then gradually expanding elsewhere, had set up non-state tribunals called Dar al-Qaza. They continue to function under this name. There's several in Delhi, for example. These granted and do grant religious divorces, and they thrive in various parts of the country. These then inspired those who set up those councils in Britain. So part of the story is scholars coming from South Asia, bringing these experiences with them to the new situation in Britain. But, and now I'm speaking of these new councils in Britain, what can they base their claims on, that they indeed have the right to dissolve a marriage? They're not set up by a state. They set themselves up in 1982 as those representatives of the community with sufficient learning and skills to adjudicate these requests by women for divorce. We will see in the rest of the talk that in attempting to adapt to anxieties about performativity, what counts as a divorce, and about British acceptability, the councils have created internal tensions, indeed contradictions, that produce specific effects. This will be what I'll talk about for the rest of this talk. So let's start with a case. In 2010, Nasira, it's a pseudonym, and we'll call her Nasira, a Muslim woman, approached a religious teacher near her home in London. She wished to divorce her husband. She had grown up in England, but she had married her cousin in Pakistan, a very common practice. This union was arranged by their parents. They moved to England and later on they separated. Nasira was planning to file for a legal divorce in court, but she also wanted proof that she was divorced religiously in case she would want to remarry. The teacher referred her to London's Islamic Sharia Council, and in 2011, at one of those monthly meetings at the Regent's Park Mosque, the 6 Islamic scholars sitting as the council took up her case. Their first aim, the scholars, their first aim, as with Islamic judges in other countries, was to try to save the marriage. But, as is often the case, Nasira's husband had not answered their entreaties to come for a joint meeting, so they had to proceed on their own. They agreed to dissolve the marriage and officially inform Nasira of their decision. With their letter, she would be able to remarry in a country practicing Islamic law, where a judge might indeed ask for such a letter. That does happen in Pakistan. Or should she remarry in England, she'd be able to satisfy relatives and neighbors, and perhaps herself, that she had not sinned. Most of the women and men involved in cases brought to the council were born in Pakistan or Bangladesh, and they're of South Asian ancestry but born in Britain. Somalis provide the next and growing largest category of petitioners. The women petitioners are much more likely to be born in the UK, that's 40% of them in my sample were born in the UK, than were their husbands, the respondents. Only about 27 of them were born in the UK. The wives were also much more likely than their husbands to be British citizens, and also much more likely to reside in the UK at the time of their application to the council for a divorce. Indeed, few of the cases examined involve women petitioners currently residing outside the UK, but some do, and nothing prevents women from conducting their cases from afar. So, let me turn now to one of the functions the council performs, which is that of mediation. Here we go. Sometimes a scholar acts as a mediator without there ever being a formal decision. I often sat in sessions with the Britain Sharia Council's director, Suhaib Hassan, here pictured. On April 29th, 2013, a husband came for what was supposed to be a joint meeting. All right, that is a picture of this event, so I'll take it out. A husband showed up for what was supposed to be a joint meeting with his wife. He brought a friend with him. Suhaib had received a letter from the wife's solicitors. They referred to a finding by social services that she should keep their son away from his father. The solicitors added that because Mum had difficulty getting childcare, were she to travel to London for a joint meeting at the council, she would have to take her son, and doing so would contradict the social services directive, so she wasn't going to come. The solicitors also relayed the wife's claim that the husband had stolen jewelry from her, and some other things. Suhaib read from the letter to the husband and his friend. So there's just the husband and his friend there. Suhaib sitting up there reading out the letter from the lawyers working for the wife. In response to the letter, the husband told Suhaib that he had already verbally divorced her. Suhaib noted that the wife had begun khula proceedings, where she asks the husband to divorce her, with the council. But because she didn't know whether his talaq that he said he was pronouncing would be sufficient. So they've settled this. Suhaib then calls the wife on his speakerphone, and they enter into a long back and forth with the husband's friend acting as a spokesperson. So the wife will ask something, the husband's friend will relay it to the husband, he'll answer, and then back. So the husband and wife never talk directly. The wife finally said that she would drop the allegation of stealing jewelry if he would agree to the divorce. He agreed and signed an affidavit in Suhaib's presence saying that he divorced her, so it was a talaq, and his friend signed as a witness. Suhaib explained that once the council received a written statement from the wife dropping the allegation, they would release the khula certificate and that no further joint meeting would be needed. It would be over without the need to any kind of a formal proceeding. Turning to me, Suhaib said, "You saw this letter. They say we don't listen to the police or social services. We get letters from them all the time." A very negative, privately produced program on the council had just aired on the BBC, and Suhaib was responding to the general charge that Sharia councils acted outside the law. Now, if mediation fails, the council starts on a series of procedures. They intend these procedures to guarantee fairness to both parties. They're also intended to persuade the broader British public that the councils should be acknowledged as legitimately providing services in a fair and open manner to British Muslims. Maybe even someday the British public would decide to delegate to these councils the right to grant legal divorces. That's not the case currently. All they do is grant religious divorces. The media have been increasing their calls for regulation of the councils. Indeed, a bill to that effect had its second reading this past fall, and an undercover investigation of the council claimed that they ignored the needs of women. Thus, the usefulness of the Council's efforts to continually adjust procedures so that they would seem to be like English courts in their fairness to both parties. So, for example, everything's based on a file. That's the unit of the British bureaucracy, and it was the unit of British imperial life, and indeed every case has a file. It's got red tape around it, looks just like an East Indies file. But there are other things that they do as well. For example, the Council requires that a civil divorce, should it be needed, that is if the couple had married outside the country or had registered their marriage in England, that must be begun before they will take up a case asking for a religious divorce, to show that they're not encroaching on or substituting themselves for the English courts. Secondly, they have a 1-year waiting period before they can give a divorce, which maps the procedures in the English courts. And finally, they undergo some of the same procedures of notification, sending 3 registered letters to the husband with 1 month apart, and then if there's still no response, they'll verify the address. So they built these practical procedures on procedures already in place in England. And indeed, they don't justify them as being Islamic, but as a way of ensuring fairness and to be sure that the marriage was really over. Now, procedure is really important, both in the way that the Sharia Council shows itself to the broader public, but also to show claimants that they're fair. Indeed, the first thing a person sees when she or he enters the offices that I showed you before is this flow chart. You're not supposed to be able to read it. I just want to give you a sense of the sort of thing it looks like. That's on the wall facing you as you first walk in the offices. And it shows a wildly complicated, but seemingly extremely rational and almost mechanical set of procedures that will go from your request to finally granting you a divorce. Now, all these procedures, instituted to ensure fairness, create complaints about long delays as a woman awaits a response. Sometimes a month between each letter, and the husband says, no, I will come, and then cancels his appearance, etc. They get complaints all the time. Indeed, the concern to ensure a fair procedure enters into conflict with the desire to end the marriage quickly. And the councils are also attacked by the media on both horns of the dilemma, that they're unfair and that they delay the process of giving the wife the divorce. But more generally, the desire to create rules engenders difficulty, as in the next example. So rules and transparent procedures are the coin of the realm in England. And the Sharia councils themselves are often accused of not having properly explicit rules. But there's a problem if you try to render explicit and rule-like what had previously been understood in the country from which these claimants come from. How does one translate Pakistani practices, that's the most common origin of clients, to a new context, where documents signed in Pakistan are not transparent to their intentions? The issue often arises for the council regarding the gift that the groom must give the bride, called the mahar. This gift, you all know what this is, this gift may be a mere token or a considerable amount of cash and jewelry, depending on both the common practices in a particular society and on the wealth or status of the parties involved. The groom may pay some of it immediately and defer the rest. The deferred part might come only due if the husband either initiates a divorce or dies. And it depends on where you are in the world. In parts of South Asia, relatives also contribute large sums of money to buy gold jewelry for the bride and the groom. In some places, the amount written on the marriage contract as mahar is very small. Social norms requiring the much larger gifts of gold. And some would say that these are the real mahar. People often do say this. The council requires that a woman whose request for a divorce is successful repay or forgive mahar on the theory that the divorce is the form called the khula, where the wife induces the husband to grant divorce by paying him something which they take as being conventionally the mahar. Technically, this means that in some way or another, the husband has consented to the divorce. This is a problem that I'll return to in a little bit. It also renders, as a rule, repay the mahar, what in classical jurisprudence was left open for negotiation between the husband and the wife. And of course, there's the famous hadith of the garden or the orchard that it's often referred to here. So this is an adaptation by the council to turn this into a rule, taken because usually the husband refuses to participate in the procedures. So there's never any bargaining. But that rules do not dissolve the difficulties, but the fact that the rules doesn't resolve the difficulty, which includes the matter of how one can tell what's mahar and what is ancillary gift. Do you look at the intention of the parties? Do you rely on the written document or on some other sort of evidence? This issue arises frequently, and I'll give you a case. Okay, this is a case from March 24th, 2010. The husband and the wife were both from Pakistan. Each party asked to be compensated by the other for expenses and gifts. One of the Pakistani scholars, Khurram Bashir, from Birmingham, argued that the wife must return the gold jewelry given to her. Another scholar, Haytham al-Haddad from Saudi Arabia, did not see how jewelry was part of their discussion if it was not written down as mahar in the marriage contract. The discussions continued between the two counselors. This is just a little bit of a very long deliberation. They allowed me to record these, transcribe them, and then analyze them. Khurram Bashir, I'll just call him Bashir from now on. Khurram Bashir, again from Pakistan. All gifts must be returned. This goes to custom, all return, even a needle. When she claims her things, she should take her movables. Immovables do not concern us, but gold always concerns the Sharia Council. Haytham al-Haddad. How should we classify these gifts? Why should they be returned? Bashir. The custom, urf, is that the mahar is low, but there's lots of gold. There was one wedding I celebrated of a doctor, and the gentleman asked me to write down 1 pound mahar. I was not happy. I asked, are you making a mockery of the wedding? I asked if they were giving gold, and they were, quite a lot, and I said they should put that down as the mahar on the contract. Haytham. Yes, but what does urf do? Does it consider this part of the mahar? Bashir. Yes. Haytham. No. Our rule is that only that which is written in the nikahnama, the marriage certificate, you should give it back. It is our rule. Bashir. No, it is not our rule. We go with urf. All right, went back and forth for quite a while. So the issue resurfaces quite a lot. Khurram Bashir argues here that gold was mahar, and that it would be better if people wrote it down as such, because often that which is explicitly mahar is laughably low. The amount is symbolic, that written down, he explained here, and it is the gold that people intend to provide the bride with bargaining power in future negotiations with her husband. If you try to accomplish the objectives, the maqasid al-sharia, then you should consider the gold to be part of the mahar, he concluded. And this approach resembles that which an English lawyer indeed might take to a contract dispute. What can we assume that the parties understood at the time of signing the contract? Haytham al-Haddad counters, as he always does, that the council should restrict their judgments to that which is stipulated in the written contract as mahar. He argues that other gifts, like other property, fall outside the council's self-imposed jurisdictional limitations. Now in this particular case, Haytham al-Haddad came to agree with Khurram Bashir's argument that the gold had intended to be part of the mahar in this case. But sometimes he refuses to go along and he'll just let them solve it, but refuses to acknowledge his part in the decision. His particular argument supports a broader and widely held view that seeks to place something called Sharia law outside of any particular local set of social expectations as a universal set of rules. This is Haytham al-Haddad's perspective. That these two views are both reasonable, they both are, I think, doesn't lessen the instability they produce, but it's an internal form of instability. There's no set way of resolving this. It doesn't appear in the council's dealing with their clients. It's only obvious to them and to me, who's listening. We now turn to a second form of instability, that of performativity, and this now does become visible to clients. Performativity in semiotic theory refers to what's accomplished by the very pronouncing of a phrase. So if a Muslim man says, I divorce you, to his wife, and he's respected the conditions set out by the law of the state where he lives, then a divorce has indeed occurred at that instance. Often performatives take the form of, I now do X. A ruler christens a boat, a parent names a child, and so forth. But what exactly does the council do by stating that the marriage is dissolved? I want to approach the question by turning to another case. This is from February 2010. And I like cases because it gives you a sense of how complicated these are. These are really human interactions. They're not simply applying a rule book. That day I sat in on a consultation with Suhaib Hassan. He was holding sessions at the Leighton Mosque because the council offices were undergoing renovation. In the third case heard that afternoon, a young woman arrived with a female friend. The woman was born in Pakistan, but now lived in Canada, and her friend was from Malaysia. This sort of complex transnationality is not at all unusual in these cases. The woman had petitioned for civil divorce from her husband, who had also been born in Pakistan. He had not contested the civil divorce. And now she had the degree absolute, that's the final stage in an English divorce, in hand. She was there to begin proceedings to obtain an Islamic divorce as well. So they're divorced civilly, the husband had not contested that divorce in English court, and now she comes to get her Islamic divorce certificate. Suhaib questioned her, and she stated that she'd never received the promised mahar, but that the husband insisted that he had paid it in full. They had a number of other financial disputes and had argued those out in the civil court, and those are not decided by the Sharia councils. Suhaib informed her that because the husband had not contested the civil divorce, he should consent to an Islamic divorce. Normally, he explained, the council writes the husband to get his point of view on the case, and does so twice again if no response is received, which often is the case and which delays the case for many months, as I said earlier. But Suhaib said that in her case, quote, "We are not required to write to him because he did not contest the civil divorce, and that the procedure would be rapid." But he added that, quote, "It is a matter of khula, so he does not have to pay you the mahar." It appeared that she had come prepared for this eventuality. She wanted the mahar. For she then read aloud from a sheet of paper printed out from the Islamic Sharia Council's own website, where it says that if the husband does not contest the civil divorce, then the divorce is also Islamically valid. She asks Suhaib why her husband does not have to pay the mahar he owes her. She thinks they're already divorced. He didn't contest the civil divorce. Suhaib responds by quoting the next part from the website, where it says that if she comes to the council and starts the procedure, then it's a khula. He reminds her what that means, that she loses the right to mahar. This goes back and forth until she turns around to me and says, "You speak English, what does this mean?" We don't like this when we're trying to be flies on the wall and just observe. Often I was drawn into cases. She hands me the printout of the website. It does indeed say both these things. I waffle and say that perhaps the ISC is saying, the council is saying, that a woman has been freed of her marriage by an uncontested civil divorce, but if she wants to undergo the council procedure, then certain consequences would follow, giving up the mahar rights. She indicates her frustration with the whole thing, but says that she'll go ahead and take the next step. Now, she had run into a particularly complex dimension of the council procedures. This will seem minor, but you'll see in a minute how far-reaching this can be. Suhaib was willing to take as proven that the wife hadn't received any mahar on the basis of her willingness to swear an oath to that effect. It was also said to presume that the husband had agreed to a khula divorce because he hadn't contested the civil divorce. He was trying to move things along. He's always like that. These two presumptions permitted Suhaib to not contact the husband. Other members of the councils might have challenged Suhaib's presumptions. They might have said, and they have said regarding other cases, why should we believe the wife? Furthermore, there's a difficult matter of determining the husband's intention, his niyyah, which is juridically crucial, as you all know. As the council secretary, Atif Matin, had explained to me, quote, talking of the husband, sometimes even if he did initiate the civil divorce, he will not agree to khula, and he will say that he intended to divorce her only in civil fashion, that he did not formulate an intention, a niyyah, to give her a religious divorce. And so we have to give the wife's request a full formal examination. We have to contact the husband. And if then he asks for a full refund of mahar, we will require it. This matter often leads to disagreements among the scholars. Suhaib tends to argue that if there's a civil divorce, the council should forthwith grant the khula divorce on grounds that it makes little sense to do anything else, the marriage is over, and others are more sticklers about following procedure. Suhaib also reminded the petitioner that although the civil divorce allows her to get on with her life, if she wishes to complete the council procedures, she will have to be willing to renounce any claim to mahar. One might find this in contradiction with the notion that she should be considered already Islamically divorced, as it says on the website. She so found it. But this is essentially, here's the critical part, this is essentially a way for the council to forestall the objections that husbands make about the legitimacy of the council. Husbands, whose Islamic marriages the council has dissolved at their wives' behest, often call up to berate the secretary, the poor Atif Matin I mentioned earlier. These husbands claim that the council has no right to dissolve the marriage. But they're less likely to protest if, first of all, there's been a civil divorce, and secondly, if the council has said they didn't have to pay the outstanding mahar. That calms them down. So, the presumptive procedural rules at play in this example allow the council to proceed as if no mahar had been paid and the husband did not contest the khula. Their practical ability to maintain these presumptions rests on another rule that once a woman begins the divorce action, it's presumed to be a khula action, which will lead to her loss of mahar rights. That's just to sum up what I've said already. These are presumptive and undefinitive rules in that the council on each count could find to the contrary, could find the mahar was paid, could find that the husband actually opposes granting the khula. Sometimes they'll call him up and he'll say, yeah, I didn't contest it, but I don't want to give her khula. Or that circumstances, going the other way, they often find the circumstances indicate that the woman should be paid her mahar or not be directed to return it had she already received it. For example, if she's poor, she has children to bring up, they'll say she needs it no matter what the rule of khula is. So the rules have strategic value for the council, in that they allow the council to grant the religious divorce more quickly, as in this case, or to say to an irate former husband that he retains mahar rights. This practice is a practical compromise among three ways of understanding precisely what it is that the council does when it dissolves a marriage. And these are actually issues that go back into the history of Islamic jurisprudence, so some of you may find echoes with elsewhere. So let me just recall for you the three main kinds of divorce as they're understood. I realize there are more terms for different kinds of divorce, but these tend to be the three ways it plays out. The husband divorces his wife, the talaq. The wife persuades her husband to divorce her by giving him something, the khul. Or the wife asks the judge to dissolve the marriage on specified grounds, a fasq, or there are other terms sometimes used, sometimes thought of as an annulment, usually just called a dissolution by the council, using only the English term. So the first understanding of performativity here, of what the council is doing, is that the council has taken on to themselves the authority to dissolve the marriage. So what they do is they carry out a fasq themselves on their own rights. So under this reading of their actions, their pronouncement that you are now divorced has performative value. So they're saying this is what causes the marriage to end. And in this case, the scholars really function as qadi, they function as judges. Now, if they were a court, back in Pakistan or in Indonesia or perhaps here in Qatar, they were a court, they would be able to summon witnesses, and certainly the husband, and if they decided that he was at fault for the breakdown of the marriage, then they might decide to award the mahar to the wife even if she brought the litigation because he was at fault. This has become the practice in many Muslim-majority countries. I know nothing about Qatar practice, and I hope to learn something during the discussion. Certainly in Indonesia, where I continue to work a lot, in many other Muslim-majority countries, where post-colonial legal reforms led to kind of a general women's divorce, where a judge dissolves a marriage and disposes of the mahar according to who he thinks or she thinks is at fault. In accord with this idea, when they discuss these matters with me, the council scholars refer to what they do as a fasq, or a judicial annulment, or a dissolution. That's how they talk about it. But they're not a court. They don't have any powers to subpoena. They can't really find fact in any kind of effective and satisfactory way. The husband never bothers to come. They don't really think they can prove much of anything. They're very aware of this. For that reason, they never use the words qadi or fasq in speaking with clients or on their website. So Islamically, they see it as a fasq, but they never talk about it that way to anybody else, and they never write that word down. Okay, that's one understanding, right? That the council carries out a performative act and dissolves the marriage on their say-so. The second understanding of what the council does, let's say in the same observed action, is that they mediate a voluntary agreement between the husband and his wife, whereby the wife repays or forgoes her mahar, and the husband agrees to give a divorce. Under this idea, what they're doing is they're facilitating by arranging things such that the outcome corresponds to that of a khula, second kind of divorce, where the husband agrees to pronounce the divorce if his wife agrees to forego payment of the deferred mahar. So, following this reasoning, the council's website refers to their procedures as khula. That's the term used on this. But often the husband does not agree to the divorce, and thus it is difficult to see the act as one of khula. In an effort to reconcile this conflict between the idea of a khula and the absence of clear agreement on the part of the husband, Suhaib and some others infer the husband's agreement from his failure to contest the civil divorce, or even from his refusal to answer letters addressed to him. That's why the letters are so important. Then they can say, well, he doesn't care. We can assume he gives his agreement. That's a big jump. As the council secretary, Atif, said to me, quote, sometimes the husband just ignores the whole thing. But when he receives a divorce decree, then he knows there's no more he can do. And someone else might tell him, hey, you can get back the mahar. So he comes by then, and we give it to him. It's a sort of a halfway khula. Not a known Islamic legal category, to my knowledge. To cover our backs. so that if the husband complains, we can give him the mahar. Okay, that's the second understanding, the khula, or as the secretary somewhat jokingly put it, at half the khula. There's a third way of thinking about this, which is that the council is witnessing the dissolution of the marriage contract brought about by the couple's civil divorce, or in the absence of such a divorce, by the fact that their marriage has ended, it's fallen apart. And this is the sense of that clause on the council website that one clever woman read, saying that, in fact, that was the case. Once they had divorced civilly, the marriage was over. The civil divorce was valid Islamically. At the Birmingham Council that I showed you pictures from earlier, run by women, they often say that to women. Several times I've heard that R Bowen say this, you know, you didn't really have to come here, because by virtue of your marriage being over, you were really divorced. Marriage in Islam is a contract, and the contract is done, the marriage is done. She would say, but it's a good thing that you came, because the certificate could be very useful for you. You know, should you wish to remarry, and so should someone challenge you. So that is the notion that the divorce actually happened prior to the couple arriving at the council, and doesn't have anything necessarily to do with the civil divorce at all. That the council's role is reduced to certifying something that's already occurred. Right? So three different outcomes. Problem is that in all these three ways of understanding what happens, that it's a performative, that the council dissolves it, that there is a khula, that they just mediate, or that they simply certify the collapse of a marriage, the husbands object. They object in all these cases. So what happens? Much of what the council does is designed to accomplish Islamic tasks, minimize unpleasant visits from ex-husbands, and converge on civil court procedure. We saw some of the court procedure convergence earlier with their rules. We saw how they accomplish Islamic tasks. How do they minimize unpleasant visits from husbands? What do they do when the husband challenges the procedural fiction that he had agreed to the divorce, even though he knows he did no such thing? They mobilize myriad justifications, and I'll exemplify these rather than trying to describe. So August 2010, the council awards a woman a divorce on grounds that her father hadn't consented and that the marriage was not consummated. The father came and said, yeah, that's right, I had not consented, and the woman produces a medical certificate. Among the many cases that the council decides each year, this one seemed relatively easy. I followed this case as it was deliberated, and I happened to be in the office in August, on August 19th, when the angry husband calls the office, talks to Atif Matin, that secretary, to say that he does not see how they can divorce them when he did not consent and they did not prove the wife's claims. Right? So it's not a court, they couldn't prove anything, and he didn't consent, it wasn't a khula. It couldn't be a fas, it couldn't be a khula. He has words with the secretary for about 20 minutes. So I hear Atif's side, which is a series of justifications, and I, in some cases, reconstructed the husband's side from talking to Atif afterwards. So I'm going to give you this, the way a stand-up comedian, very famous in the United States, named Bob Newhart, maybe none of you have ever heard of him, but he used to have this wonderful act where he would be on a telephone, you'd only hear him, and you would know what was going on the other end. It was very funny. This won't be that funny, but that's what I had. That's what I listened to. So this is what you'll hear is Atif, and sometimes I'll put in a little bit of what I know the husband was saying from talking to him afterwards. Okay, Atif. So the husband's called to say, what are you guys doing? I couldn't be divorced. You're not a court, and I didn't consent. Atif. If a woman says she does not want to live with you, do we force her to do so? This is delay, there's time here. As human beings, she cannot ignore her parents. I've heard this, the husband's complaints that the council doesn't prove anything, a lot of times. At the end of the day, God will hold us responsible. The Quran says, don't keep them in limbo. Yes, it is there, meaning that's a true verse. She said there was no consummation, and her father said he did not give consent. After 18 years of bringing up a daughter, what do you want? To marry her off in a respectable way, or have her show up and say she's gotten married? Will any Muslim of the 1 billion prefer that? I've seen hundreds of cases of this nature. No marriage without the wali's consent, he repeats it and then cites the Arabic. It's a hadith, brother. What's the solution, brother? How can you move forward? She provided a doctor's report. You provided no evidence to the contrary. Husband's talking now. We asked you for interviews. Did you come? We invited you to a joint meeting. Did you come? They never come to these meetings, so when Atif responds by reciting procedure, always puts him at a psychological advantage. It's up to the husband to reconcile. She provided copies of all your emails, and you are so rude. How do you expect her to reconcile? Read what you wrote, brother. The etiquette a person has nothing to do with a master's degree. Are we supposed to have a magic wand to reconcile you? And now the husband starts criticizing the wife's conduct over the phone. Why do you want to keep her with you as your wife then? In Islam, either keep them nicely or leave them nicely. We go into the basics here. More from the husband. She is saying no intercourse, that it wasn't consummated. If you were in the judge's shoes, what would you say? And the husband now mentions, well, she could have had hymen repair surgery to make her look like a virgin. You were saying she's done this just to get a divorce? She's come here personally, once in Bradford and once to London. This shows her intent to have the divorce. It is not her parents pushing her. Done. Okay, if for the sake of argument, brother, she were lying, what would you want us to do for the future of the marriage? Now he starts complaining about her behavior again. She accepts that she wasn't forced into the marriage. So what? What is the future? So that neither party falls into zina. You can send us an email and we'll forward it back to her about what you want to do, but otherwise we dissolve it on grounds that the marriage cannot go on. The decision on the divorce won't be final until September 15th. We will see if the wife is willing to come to a joint meeting on the 15th. At this point he says he can come. But I will need to ask a senior scholar. None of this happens. There's no joint meeting. The husband never shows up again. The divorce is declared final. This is usually the outcome of these things. Atif has cleverly relied on procedural justifications. You didn't show up, brother. And on various scriptural grounds for freeing the wife and condemning the husband. This usually works to quiet them down, which is all that he wants. He just wants to get the husband off his back. Along with the fact that even in cases such as these, the wife is asked to return any mahar paid her, which the woman in this case did do, and the husband did come by and collect it. She gives it to the council, the husband comes by and collects it. More often than not, the husband doesn't come by. It's given either back to the wife or to charity, depending on her instructions. Right. So as you can see from this sort of example, they're really on the horns of a dilemma. The legitimacy of the councils is attacked by irate husbands, by wives frustrated at delays, which usually follow from the husband's efforts to stall the procedures, and by many in the media and various think tanks who see them as a creeping replacement of English law by Sharia. The London Council responds by establishing and continually adding to rule-like and court-like procedures. They even have that wildly complicated flow chart on the first wall that you see when you enter their offices. But rules, such as those that are implied by that flow chart, rules require translations from the practice of judges in particular countries, and then run into a contradiction between a universalistic view, we should apply the same rules everywhere, that was Haitham al-Dad's position, and a context-sensitive view of marriage and divorce. We should apply what makes sense in the context of the people involved. And so we saw this in the exchange over mahar, we see it in many other instances. Furthermore, the rule-like procedure ignores the claim that either husbands should consent to a divorce or the council should be able to approve in court-like fashion the wife's claims. Now, above and beyond the particular case, and I'll conclude on this observation, above and beyond the particular case of the council in England, this instability is the result of the specific conditions of constructing a quasi-judicial institution without a legal base, without any enforcement power. A similar instability seems to characterize the workings of some of the Indian Dal Qaza, or at least has led to very recent legal challenges in Delhi, explored by several anthropologists recently. Given all this, the instability, the backtalk from the husbands, the sheer annoyance level of being a judge and a secretary in the Islamic Sharia Council, we can now understand why at the end of one day, Suhaib Hassan turned to me and said, I wish they would just all go home, but we have to listen to them and resolve their problems. Thank you very much.
Well, thank you. I have a few questions, but I'll open the floor first. I think it's fully fair. Thank you. That was very rich. As something that both combines fieldwork and more. So, any questions from the floor? Any questions from the floor?
Yeah, right here. There's a woman right here first, I think.
Anya, do you want to ask a question? Yes?
It's not your finger up there.
Adi?
My name is Ade from Indonesia, final year student in the CMS program. Actually, I prepared some question because I read your article. So it's like I want to ask regarding the notion of abstracting Sharia from local culture. Right?
So you read this article? It's not even published. I'm already reading it.
No, the other article.
Net is way ahead of us here.
But I think I can connect it somehow.
Okay.
Yeah. So regarding abstracting Sharia from local culture.
Yeah.
I couldn't see like how we can like perfectly in the nation state context how we could attach Sharia to each cultures, because cultures are very diverse, right? Like in Indonesia we have 300 ethnics, right? Also in England probably there are many
People come from different countries.
Yeah. Different countries. So in my idea is like there are three alternatives to abstracting Sharia. It's like first you got pure fundamental Sharia without considering local context, which you said, actually. And also the other is like to follow Sharia codification in one nation state. Actually, it's also somehow also abstracting, right? Because it will follow one procedure and distancing from other culture, right? You can say like that. And the third one is like what experience in Indonesia, where one professor he tried to make a counter to what already exists, compilation of Islamic law. He tried to bring a sort of quote-unquote liberal, which is actually also we can say also abstracting Sharia from local, because local, like this law allowing homosexuality or these things, right? As probably you know. So it's also abstracting. So my question is how we can really attaching to culture, while culture are diverse, and in the context of nation state, even codification will also require somehow abstracting from culture.
I think given that it's this time one, because there were actually three, fairly complicated. I want the audience also to remember it's an excellent question. It's really a fundamental question, isn't it? You're thinking about the relations between positive law, particular practices of fiqh as they're worked out by scholars in particular countries, often bringing in elements from local circumstances. I mean, you go back to Umar and others, they were already doing that, right? And then these questions of what you do in a place that's not a Muslim majority society at all, like Britain, where you've got, and you don't have the legal institutions to fall back. So the first, let's go back to that example of Haytham al-Haddad and Khurram Bashir. It's always important to, I think, to look at a particular kind of example so we can be somewhat concrete. They weren't talking about culture at all. The argument there was, do we come up with a universal set of procedures, and not necessarily universal Sharia, but at least a universal set of procedures for our institutions. So if it says mahar on the nikahnaama, or if it says mahar on an American contract, or it says mahar on anybody else, we will simply take it as it's written, right? So it's a standard set of procedures that could apply no matter where the people come from. That was his alternative. It's a reasonable one. Khurram Bashir said that actually, if it's a contract, we have to think about what they had in mind. What are the usual practices? It's not about culture. It's about the people who signed the contract. What did they intend? That's part of contract law. If it's reasonable to assume that they would have meant something, then you can infer that meaning from the very fact of signing. If it's not reasonable, and Khurram Bashir said it's not reasonable for the Pakistani context to assume that when they signed the mahar contract, it was only like 2 riyals, you know. That's not possible. They clearly meant much larger amount, which, even though it wasn't written down as such. So that's actually about how we think about a contract. We don't have to have recourse to culture. Now, the third case would be a very different case, and you alluded to this, very important. If a nation state passes a set of laws or codes, as in the case of the Kompilasi Hukum Islam in Indonesia, in the Indonesian case, then what do? They also, you said they also abstract. Yeah, they do. They come up with a set of substantive articles, and they come up with a set of procedures, in the Indonesian case, it happened to be, you know this as well as I, through a process of looking, having different scholars, different parts of the country involved, and they came up with a kind of a consensus view, which in fact doesn't have consensus. There are a lot of people, a lot of Islamic scholars and practitioners in Indonesia disagree with it. Like Wasiat Wajibah, for example, highly contested, etc. But now we're talking not about Sharia, we're talking about hukum positif, we're talking about positive law, right? So positive law is always, in any country, if this is not true for Qatar, please tell me, but so far in my experience, for any country, positive law is going to select some views and not insert others, because it's the nature of Islamic jurisprudence that you can have pluralism. You can have different, reasonable, learned interpretations of Quran, Sunnah, etc. Right? That's built into the very fabric of thinking about what fiqh and Sharia is in Islam. So once the legislature legislates, well then yes, it is fixed. It's not so much abstracted, but it's fixed, and it will select certain. That's just a feature of law. So depending on the context, we have different things. We've got people saying in Britain we need general procedures for what we take as evidence. We have people saying you've got to look at the intentions of the party signing a contract, and then we have this other issue about how positive law differs from Sharia and fiqh.
Thank you very much for a very interesting presentation. I actually have a series of questions. Firstly, I'd like to ask you about your own point of view about the accusations, given that you've studied in terms of unfairness or that they don't have explicit rules or whatnot. I'd also like to ask about your point of view in a North American context versus a UK context, because in the last little while, Toronto has had, protests against Sharia councils, and there was this whole issue that came up in the news. As far as I understand, I think in the US there's several of them. I'm not sure about that. I've been told that there may have been. I don't know if they still continue. I'd also like to ask you about what are some of the causes of these divorces, given that you've studied this in depth. And does the issue of what is in fiqh called mata' al-talaq, where a husband actually chooses to dissolve the marriage, not out of any fault in the behavior of the wife, but just because he did choose to actually dissolve the marriage. And
because he what, sorry?
He did choose to decide to actually dissolve the marriage, not because of any fault of the behavior of the wife, or anything to do with the wife in particular, but for some reason he decided to do that, where he would actually pay the wife in this particular thing, in compensation. So it's called mata' al-talaq. Is that brought up?
Yeah.
And finally, why was khul' brought up in the first scenario where the friend was basically the messenger, where the husband actually said, okay, I divorce you?
Yeah.
Why was khul' brought up? It didn't have to actually be brought up because he already divorced.
Yeah.
So I'm not quite sure why the council itself would actually go. Thank you.
Yeah, let me do the first one, and I better take these because they're very excellent questions. Let me take the last one first because it's very easy. Yeah, you're absolutely right. She didn't. She wasn't sure that. She just didn't know. She was confused. She wasn't sure that his talaq would be enough. She thought she might need a certificate from the council to have a piece of paper. The council would issue a talaq certificate anyway, but it would be to the husband. She could get a copy of it, but she didn't know this, so she said, to be sure, let me have a khula also. People have all sorts of ideas when they walk in, and as we saw in this case, of course, the council they didn't do anything. They simply, once they had worked out this agreement between the two parties, and they said, okay, you give her a talaq, she'll drop the accusations about stealing, and then once we get the talaq, she signed the affidavit. Once we get the thing from him, then we'll. No, he signed the affidavit. Once we get her agreement to drop the charges, then we'll send out the certificate. But no, that's absolutely right. The others are more substantive. I mean, that was substantive, but the others are My view on what they're doing, well, I have a soft spot for judges of any sort, anywhere in the country. My father was a lawyer and a judge for many years. He's still alive, but he's not working as a judge. And I see them as often very heroic, trying to solve difficult problems in difficult situations, and usually getting some sort of blowback by somebody. So, it's a difficult sort of scene to be in, especially when they are bearing the brunt of all these criticisms from others in England that they're trying to substitute Sharia for English law, and it's very, very difficult. Now, there's 2 points to make here. So I am very sympathetic. That was the direct answer, but 2 brief points along these lines. One is that Sayyid Hassan in particular, Faisal Akhtab As-Siddiqui, the Sufi peer, who I just briefly mentioned, he's a barrister, he's a very smooth talker. Sometimes he just sort of lulls you to sleep with his smoothness, You can see how he could be a good barrister. And you're not quite sure if he said anything when he's through, but he kind of slips through. Nobody really kind of latches on him. Sayyid Hassan, he's terrible at PR. And he has these brilliant children. Osama Hassan, who was involved in a controversy about evolution at the Leighton Mosque. Maybe somebody heard this. There was a huge flap about it. There were death threats against him. And Hola Hassan, his daughter. These people all have MAs, PhDs from various things. Osama Hassan is a PhD from King's College in artificial intelligence. I mean, these are really highly educated, bright people. The father and the mother, dear people, they have no PR skills. So once when I just met Sayyid Hassan, who I really like a lot, really appreciate a lot, he drove me back into London, central London, in his car. He was going into a radio thing. He said, Joe, I'm going to talk about why it's okay to beat your wife. What do you think is the best reason? I said, just drop it. Just don't go there. He wanted to defend the Daraba verse and say why it's really important to beat your wife. And then he was on record by saying, if you just chopped off a few more hands in Britain, there'd be much less crime. Well, that may be true, but is that really what you want to lead with if you're trying to just make a case that you're doing something very limited? So very poor PR skills, and his children are constantly upset by this. His mother was recently showed in this undercover film talking about how women should be nice to their husbands and they should dress appropriately and they should cook at home and stuff. I mean, really, for England, it's not the right tack to take. It's just not very strategically smart. So he kind of contributes to some of this. The second thing, though, I wanted to say on the other end was that I know a lot of family barristers and judges, and they have no problem with what the Islamic Sharia Council does. They're very aware of what they're doing because they know that they're not doing something that has a legal force. They're doing something that takes care. They provide a different good, which is a religious divorce. So there are elements in society that are quite supportive, in the background, and this is very important when bills come through the Parliament that will try to do something to them. There's one that's still it probably will die out, put forward by a woman named Baroness Cox. We can talk more about that later. North America, there was of course this big controversy in Canada. Again, very poorly handled. There really wasn't a kind of an ingrained level of custom or being used to practices of Sharia councils the way that there was in England for a long. 1982 was quite a while ago when these things started in England, and in Canada it was new. It was in the state of Ontario. Nobody knew what was going on with Sharia councils, and the guy who was leading the charge to have Sharia councils said, "Well, once we have them, it'll be obligatory for all Muslim women to come to these and not the courts." Well, that's not a very good place to start. It's not true, for one thing, if it's really just granting Islamic divorces, and that killed it. In the U.S., where often when I travel, I will look to see who is giving Islamic divorces in my city of visit. So there's a whole range of things, just very briefly. There is all the way from a Sharia council for Northern California, which was started by a guy who was involved in Birmingham in 1982 in the discussions that set up the English one. And he runs it entirely in Urdu. It's all Hanafi, but very much modeled after the English. So these people know each other, right? And just another example, it was in Columbus, Ohio, a medium-sized city, a large population of Muslims, many Somalis, many others. An Egyptian doctor who happened to be running a charter school, this is like a publicly supported, almost private school, was asked by members of the community if he would not sit and grant dissolutions of marriage, because somebody had to do it. And he said, well, I fear God, I don't dare do that unless if the imam of the mosque where the husband normally worships would sit with me for a case, then I would dare do it. So he does that, but he doesn't want to do it. He's sort of he's not trained in it, but then again, it's not that complicated. He's a doctor and he's from Egypt, so he could figure it out. this is a burden that many people do not want to have put on them. And just one final, final note on the US. What I see developing in the United States is actually a practice of writing mahar contracts before marriage that will not mention Sharia, will just mention, I, the husband, agree to pay you X amount if we divorce or if I die. And because those can be enforced in courts. And America is much more open towards prenuptial agreements than is Great Britain or England. So that, I think, is the way of the future. I'm trying to read what I wrote here. The talaq thing, and then I'll come, I can't remember the third. Remember what the third one was? I can't read my writing.
Causes of divorce.
Oh yeah, right. Well, I have a very, I was granted access to their archives. So I spent many, many days sitting up in their attic. I could actually watch the new Olympic Stadium being built. It was not that far from Leighton in East London while I was pouring through all these cases. And they tell a very sad story. I was, of course, reading only about marriages that went bad, right? Because these were divorce cases. One typical case, of course, there's lots of reasons. A lot of it has to do with incompatibility based on background. Very often, highly educated, or uneducated wife, but with a first degree in university. A cousin, very often these are first cousin marriages arranged by the parents, from, say, Pakistan, for example, brought over. Now he gets a visa, he gets to come to England to work, she's supposed to help him out, and they're mismatched in terms of education level, it doesn't work out. The family mixes in, and of course, it's the same family for both of them. It's, nobody wants this, and so they split. That's probably the most common single cause. Finally, the talaq, where the husband pays her. Yeah, I haven't run across this in England. It's very common in Indonesia, though, to require that a payment, they're called muta'ah. It's mata, yeah, be paid to the wife as a gift from the husband, but the level is now set by the court in Indonesia. And this follows the Supreme Court admonition, which wasn't an official, it was just a sort of an oral admonition to the Islamic courts in Indonesia, that this be set high because women are having trouble getting money from the husband in other ways. For example, going through the husband's employer, which they should be able to do. It doesn't work. So now, increasingly, judges are awarding these amounts based on the husband's ability to pay. But I don't see this coming up in England.
Other questions? I can ask a few points.
You're thinking still, though, right? No, you had your hand approved. No, okay. I don't mean to embarrass you. I just thought it's nice to have women asking as well.
We didn't have any female participants in the questions. But if I may intercede, a number of points. We're talking mainly about England rather than all of the UK. But you mentioned one question. You didn't mention this. I don't know who funds these councils. That's the question. Where do they get their money from? And another crucial point. There was a talk about urf and the various influences of the context, and there's some things you mentioned specifically about Pakistan. This is definitely tradition.
Yeah.
But this brings in the issue of which you mentioned the debate, the different schools in there. You talked about Birmingham, which traditionally, I mean, it's the biggest, as far as the biggest Muslim city in Britain. And it was a very strong base with one of the most conservative, Salafi, Jihadi leaning British Muslims. Like there used to be Muhajirun there and Omar Bakri and whatnot.
Green Lane sponsor.
Yes. So, did that lead to conflicts within that community? Because you mentioned Sufis, you mentioned, I mean, obviously we're all talking Sunnah, right? We're not talking Shia there.
For the moment, yeah.
Yeah, we're only talking Sunnah.
Yeah.
So, but within that Sunni realm, there must have been clashes and conflicts. And that brings me to another question about this. So, these are all, the marriages are annulled and accepted communally, even if not necessarily legally by the community. But how about the marriages? Do they also do marriages?
I mean, it's the civil. Oh, sorry.
Yeah.
Islamic marriages.
Yeah. Do they also do marriages?
Yeah.
So, these are my basic points. Thank you.
You're welcome. So, you get several questions. Let me just take yours. Marriage is the easiest one. In Britain, Britain versus England, just first of all, the legal system is the law of England and Wales.
That's right. Not
Northern Ireland and Scotland have slightly different. So you have to be careful to talk about the law of England and Wales. And then if you want to get really technical, say, well, to what extent does this also apply for Northern Ireland and Scotland? Mm-hmm. So I often say England because my lawyer friends remind me of this. I only really looked at England. There's a little bit. There's something in Glasgow. I mean, there's no reason why all over Britain you couldn't have these, but I really only know about England. Marriages in England and Wales it's called registered. Rather than having a civil marriage, you register the marriage. So you go to registry and you write something out, and the marriage is now registered. You might have had that marriage in Pakistan. You might have had it as a nikah in a mosque or at home. Most of them are at homes, not in mosques. But you can go to register it then, making it a legal civil marriage. Increasingly, this is really an important issue in Britain right now, policy issue, because mosques, let's see, it's a place that is authorized to perform a civil marriage and not a person. In Scotland, this is why it becomes important, actually the person can carry the performativity of performing civil marriage with him or her. So an imam in Scotland, whose mosque was already approved to give a marriage, could go to a home. The Church of England has an exception, of course, as in all things, and the priest can go to somebody's home. But generally it is a place that is basically considered to be a substitute for the civil registry. So there is a campaign on to have mosques register marriages whenever they're performed. Indeed, the Birmingham Central Mosque, for example, will not perform a nikah unless there's also a civil marriage. And I remember one time during one of these sessions, it came up that somebody had a nikah but not a civil marriage at that mosque. There was a huge debate about how could that have possibly happened. Oh, it was when so-and-so was here, he was asleep at the switch, etc., etc. But it's not supposed to happen. The problem is that most marriages don't take place in mosques. The reason for the campaign is so more women have the protections of civil marriage, largely, especially for the house. If a woman is not married civilly, the house is in the husband's name, she's out of luck. So there's a big debate about this, just to give you an idea of how complicated it is. Birmingham, there is my sense of Birmingham, yes, there are, Deobandi versus Sufi criticisms from the pulpit, so to speak, about overly worshipping the Prophet Muhammad as if he were God versus ignoring our Prophet, the usual stuff that you all know about. You get that there too. But actually people pretty much have their own mosques, they go their own way. The Birmingham Central Mosque is the only mosque I know of in Birmingham, I mean, I certainly could be wrong, that really lots of different people come to. It's not identified with any particular current, as opposed to the Sufi Mosque, the Green Lane Mosque, which is Salafi, which has been on television as inviting people in who are saying some pretty objectionable things. It's sort of cleaned up its act since then. So there's much less conflict than one might think, and I've been looking for it. So over the role of R Bowen, the woman in performing these divorces. Funds for these things, who pays for them, they charge. And they are financed out of those charges. These individuals are not just doing this, they're doing other things. So Hassan is the imam at the Leighton Mosque. Hatem Haddad does all sorts of other things. He gets money in all sorts of other ways. And so they get by. That's all I know about. There may be other funding. Actually, the one thing I tend not to do as much digging into as others might is funding sources. Because at some point, I'm more interested in what they do. But I know that they charge enough so that this could account for, and they have a huge volume. This could account for their income. Finally, or if I forget what you asked me about, Wolf.
Off was in relation to the difference between different schools.
Yeah.
And you mentioned Salafis versus Hanafis.
Yeah.
And these schools, I think, would put probably, I'm not an expert in Sharia, they put different limits on how they would integrate all.
Right.
And would they consider, for example, that from what you're saying, the system complements the civil law complements the common law on civil issues. So how would they accommodate that?
Right. Well, I'll just restrict my answer to what I see in the debates among these scholars on the Islamic Sharia Council London, which also already has several different backgrounds. So Hatem Haddad from Saudi Arabia considers himself to be a Salafi, reflecting a position in Saudi Arabia. Although one day two very well-respected shuyukh came through and listened to Hatem Haddad go on and say, well, brother, that was true 20 years ago. We've really moved on, like about women working and things like this. So sometimes he's caught up, he's hoisted by his own petard, as we're saying, at least in America.
Hatem Haddad is the one who's educated with Saudi.
Yeah. Well, so was Suud Hassan. So each of these people have complicated biographies. So Suud Hassan, originally from Karachi, has spent time in Saudi Arabia, was first taught by his father, who was a well-respected religious scholar, and considers himself to be al-Hadith or Salafi, not Hanafi. The two or three other major scholars on the council tend to reflect a Hanafi position. by Qurabashi, who was emphasizing urf, right? But I think that it's less a matter of madhab than it is of how you think about the rights of women, men, what the goal is. So Suhaib, who identifies himself as a Salafi, is the one who's most concerned about getting the women free of the marriage, quickly. Haytham al-Haddad, would also identify as a Salafi, is the one who's the most stickler about the rules. We can't just let these women get away with anything, and we have to protect the interests of the parents, of the father, sorry, the father. Another Hanafi scholar is closer to Suhaib. So it doesn't really map out in terms of the reference to urf here, so much in terms of Hanafi versus something else. I think on this particular issue of the gold, it may, because Quorum is so interested in paying attention to what happens in Pakistan. But the justification doesn't have to be put into madhab terms. And I've never heard anybody citing a particular madhab in justification for one or the other position on this issue. But they tend to say, but the Jumhur say, or the other will say, no, they don't. They're looking for a consensus view. Yeah. Even one about how long do we have to wait before somebody's, if a husband's disappeared, how long are we supposed to wait before we declare him dead and allow the woman to get on with her marriage, remarry by dissolving marriage? And one of these fellows said, well, one school says 99, one school says 60, let's say 1. I mean, they're just pulling it out of the air. It's very much grappling with the practical realities of living in Britain. Yeah, but it's a very good question. And if I talked to more Hanafis, and if they were consistently representing the oral position, I should say that one of the other scholars on the council, who's from Bangladesh, Hanafi trained, and says I'm a Hanafi scholar, doesn't side with Qurabashi, the one who was up for the urf. He just kind of stays out of it. He doesn't care about it particularly.
Okay.
So I think it's more personalities and how they think about how we should adapt to life in Britain that's driving them.
Adi again? I mean, there's a question for the
There's a
next
question.
Is there a question? No, wait, please, just for the translator.
There's one down here. Maybe you can take that one up.
Does the Sharia councils, or do the Sharia councils have any legal, are they registered under any legal structure? Like, are they a limited company or are they a charity? Because like if in Malaysia, if they were to operate like that, they would be considered as a forbidden entity. It's a legal and unlawful entity.
Yeah.
And it will create a lot of problems.
Yeah.
But what about Britain?
Yeah. I actually don't. I'm trying to think of the answer. I'm not sure of the answer. I don't believe they're registered with the Charity Commission. Mosques are. They wouldn't have to, but they get fiscal dispensations, tax breaks, if they do register with the Charity Commission. And indeed, one of the other Sharia councils, the one in the Sufi one, let's call it that, has been involved in mediating mosque disputes at the behest of the Charities Commission. I don't believe, I should know this, but I don't believe that the Sharia Council is. In Britain, you have much more freedom to form associations. I also work in France, in Britain, and there's a huge contrast there. It's very difficult legally to get proper legal status. In Britain, it matters less. It's very easy to register as an association. I don't know that they're anything more than that. I should check on that, though. It's an interesting question. I should know more about it. Sorry, I can't answer it.
There's a question here. Anybody else? Adi and...
Actually, I have the second question, but I just...
one question or 5?
One
One more. Sorry.
One more. Actually, you spoke about intentions. Should be considered as a basis of ruling, right? Ruling in this context of consent, right? They should consider about intention also. But however, I don't think that intention should be the basis for ruling because, like for example, the small amount of mahar. Right?
You have to talk into the mic.
The small amount of mahar, which should be returned, right? And also including the gifts, right? So as a part of culture, it's true that intentions are at work during the marriage, right? But however, in legal proceedings, if that legal procedures stated that people in a particular society consider gifts as included in mahar, then it is shouldn't be the intention which count, right? It should be the written ruling. So my question actually, how could the intention be as a part of to decide a case? That's what I got from you. That as if you are saying that we have to consider intention, like in the terms of gift, right? It should be returned if the marriage dissolved. But this intention is something abstract, and we cannot break it.
Okay. No, I understand. Actually, I wasn't arguing one or the other side. I was just showing you this debate over this issue. There's a technical difference here. So Nia came up a number of times in the talk, but not about the gold. Nia came up in terms of whether the husband intended to give his wife a khula by virtue of not contesting the civil divorce. What was his intention? And you're absolutely right, it's very difficult to know, and that's why the council says, well, it must have been this, and then the husband can say, well, of course it wasn't. I didn't intend that at all. And then you have this long debate, and that's where the secretary tries to just get rid of him by snowing him with Quran quotations and all sorts of stuff and say, anyway, you can have the mahar back, right? So that's where Nia came up. The argument about what we should do, does Urf have legal status? That's really where the argument was here with Quran Bashir and Haytham Haddad. There the argument is about what do people normally do? Not what did each individual intend, but what do people normally do? So what would it be reasonable to expect that the parties entering into this agreement would have expected the outcome to be? That's a standard element of contract law. Even though we can't always know each individual intention, there's this notion of a reasonable expectation that has legal force. And that's the sort of thing that could be appealed to in the English context. Now, Quran Bashir put it solely in terms of Urf, right? One of the things I'm very interested in, this goes beyond this particular talk, one of the things I'm very interested in are ways in which one can or ought not to translate between certain concepts and rulings in Islamic law and certain concepts and ruling in English law or Anglo-American law. And contracts, I think, are one of the more important areas to explore this. So I wrote a law review article about that, actually, a couple of years ago, if you're interested.
Well, I would have one last comment if nobody else has anything to say. Yeah. Okay.
Thank you. Just want to ask you, you mentioned that in Birmingham there are more Sufis. Where did you get the statistics, if you do have,
Right.
what percentage would it be?
Right.
And then again, I thought you were comparing Sufi, a Salafi and Hanafi.
Yeah.
But my understanding is it's not about Hanafi like a mazhab, but Salafi not as a mazhab.
Yeah, no, thank you. No, that was very confusing. I apologize. There are really two different axes here, right? So Deobandis are also Sufis in the sense that the Deobandi school practiced tasawwuf. That was imprecision on my part. Muslims who are trying to talk about mosques in Britain very often break them down into Barelwi mosques and Deobandi mosques and then other kinds of mosques. So that's what I had. And there, the numbers are somewhat equal depending whether you look at numbers of mosques or number of people who could be accommodated by the mosque. The problem is that, of course, Deobandis might also be considering themselves to be Sufis and practice tasawwuf. So there's an imprecision there. The issue of Salafis and Hanafis has to do with the debates. So that was later in the talk when I was talking about the differences between, say, two or more scholars on the council, that they self-identify as Salafi or as Hanafi in terms of the background that they're drawing on in order to make a decision. So that's really not involved in the Sunni versus Deobandi thing, neither of which really comes in here in scholars. Does that help clarify? But the terms are very imprecise in even their usage among Muslims in India, because Sufis now come off sometimes mean Barelwi, self-identify as identifying as Barelwi, even though the Deobandis also practice tasawwuf. Some of them, people who went to Deobandi schools often practice tasawwuf too. So I apologize for the imprecision, but that's where we are. So we'd have to talk about, You can talk about Barelwi mosques to the extent that an imam is known to consider himself to be Barelwi Sufi. Who goes there, we don't know. There could be a wide range of people. You can talk about a Deobandi mosque to the extent in which the imam has gone through a Darul Uloom in Britain, maybe in Duri or something like that. But then again, who goes there, we don't know. So it's very, very hard to classify. A bit about there being more Sufis than anybody else, that's what people generally say who tried to do statistical studies of British Muslims. But I almost prefer to withdraw the comment because it's so imprecise.
I have a follow-up question on the issue of the who decides these people are qualified? I mean, obviously there's no mechanism.
No. Yep.
And nor is there a central body in Britain. I know for a fact that who decides who these people are qualified or not. It's almost like a communal process of sorts. Yep. Which in its own right is very interesting and a very fascinating subject of anthropology. But just a side comment rather than a question. It's quite interesting when you came back to the issue of orphan versus civil law. I think this whole issue of setting precedents seems more acceptable in a British context, where the whole law is actually common law, where verdicts set precedents and become law. I think that would be more difficult to accept in the French context, or in a country that follows Code Napoleon, where supposedly the law is set in stone as it is. And it's a very interesting twist as well for the procedure. And there are many laws in Britain that supposedly nobody practices, and vice versa, because it's not the norm. Anyway, so just that hopefully will be.
Thank you.
No other questions or comments? Okay. Do you have any last?
No, just thank you very much for the invitation. It was a stimulating discussion, and thank you for coming and hearing. And if you had more thoughts afterwards, I would love to hear them if we're staying around.
Well, we thank again Professor Bowen, and we have refreshments outside and food.
Okay.
I hope you're hungry. Thank you. Thank you all.
Thank you.